Elena and Marcus got married 2 years ago. Marcus is a U.S. citizen, Elena is from Mexico, and their entire life together is waiting on one process, the marriage green card. They filed the right forms, gathered stacks of documents, and now they're stuck in a maze of timelines, interview requests, and questions they're not sure how to answer. If you're trying to petition for your spouse, the I-130 petition process is one of the most searched topics in all of immigration law. I'm Kate Lincoln-Goldfinch, an Austin immigration attorney who has helped over 10,000 families navigate exactly this. This video is your complete step-by-step guide to bringing your spouse home. The foundation: understanding the I-130 petition. When a U.S. citizen or a lawful permanent resident wants to sponsor their foreign-born spouse for a green card, everything starts with the petition for alien relative. This is the foundational document that asks the U.S. government to recognize your spousal relationship for immigration purposes. It is filed by the petitioner, meaning the person who is already a citizen or permanent resident, on behalf of their foreign-born spouse. Let's be clear about something important up front. Whether your spouse is inside or outside the United States changes everything about how this process works. We will cover both paths, but the route you take and the timeline you're looking at depend heavily on this single fact. U.S. citizens versus lawful permanent residents. Two different realities. If you are a U.S. citizen petitioning for your spouse falls into what immigration law calls an immediate relative category. That means there's no waiting period based on visa backlogs. Once your petition is approved and the other processing steps are complete, a visa number is immediately available. This is the fastest possible path for a foreign-born spouse. If you are a lawful permanent resident, meaning you have a green card yourself but you're not yet a citizen, your spouse falls into a preference category. There is a quota, and that quota has a backlog. Depending on your spouse's home country, the wait for a visa number to become available can stretch from 2 years to several years. During that entire wait, you are in a holding pattern. This distinction matters enormously when people ask, how long does it take? Elena and Marcus are in the faster lane because Marcus is a U.S. citizen. But even the fast lane involves multiple steps, real documents, and real waiting. Let's walk through them. Step 1, filing the petition. Your journey begins with filing the petition with U.S. Citizenship and Immigration Services. Along with the form itself, you need to include evidence of the petitioner's status, documentation of the marriage, and proof of any prior marriages that have been legally terminated. This means birth certificates, the marriage certificate, divorce decrees if applicable, and passport copies. You will also need to pay the filing fee. The petition goes to a USCIS service center, which will review it and issue a receipt notice. That notice is not an approval. It is confirmation that USCIS has your application. You will need to wait for an actual approval notice, which can take several months. If your case raises any questions, USCIS can send a request for additional evidence, which pauses the clock and asks you to provide more documentation. This is common. It's not a denial, but it does add time to your case. Step 2, choosing your path. Once the petition is approved, the case travels in one of two directions. It either stays here for adjustment of status or it moves abroad for consular processing. Adjustment of the status is the option when your spouse is inside the United States and entered the country lawfully. The foreign-born spouse files an application to adjust their status to lawful permanent residence without leaving the country. This process also requires a medical examination, biometrics, financial sponsorship form showing you can support them, and more. The key benefit is that you do not have to be separated. Your spouse stays with you while the case is pending. One thing to note is that you can file something called a one-step and file the family petition and the adjustment of status at the same time in this instance when your petitioner is a U.S. citizen. That can save you a lot of time. Elena entered on a valid tourist visa and is still inside the U.S., so she and Marcus are taking this path. Consular processing is the option when your spouse is outside the United States or if they are inside but did not enter lawfully, which can complicate adjustment eligibility. After the petition is approved, the case gets transferred to the National Visa Center, which collects additional documents and then schedules an interview at a U.S. consulate or embassy in the foreign-born spouse's home country. The spouse must travel to that interview alone. If the visa is approved, they enter the United States with an immigrant visa and receive their green card shortly after arrival. One critical point: If your spouse entered without inspection, meaning they crossed the border without authorization rather than presenting at a port of entry, adjustment of status may not be available to them even if they're married to a U.S. citizen. Consular processing may still be possible, but it can trigger a bar to re-entry that requires a waiver. This is a complicated situation that absolutely needs an immigration attorney's guidance before you file anything. Required documents. Whether you're going the adjusting status or going through consular processing, documentation is central to your case. The government wants proof that your marriage is real, and they are thorough about it. The documents you will need to gather include both spouses' passports and birth certificates. You will need the original marriage certificate. If either spouse was previously married, you need proof that those marriages ended, such as divorce decrees or death certificates. Financial documents showing the petitioning spouse earns above the poverty threshold for their household size. 2 years of tax returns, and evidence of shared life, like joint bank accounts, joint lease or mortgage, insurance policies naming each other, photos together over time, but not too many, communications, letters from people who know you as a couple. On that last category, do not underestimate how important the bona fide marriage documentation is. USCIS is looking for evidence that you actually live like a married couple, not that you simply signed a legal document. Weak evidence of a shared life is one of the most common reasons couples face delays, requests for more evidence, or difficult interviews. The interview. In most marriage green card cases, both spouses are called to a USCIS interview or to a consular interview abroad. This is often the moment that scares people the most, and for good reason. The officer has wide discretion in how they conduct the interview and what they ask. The questions can range from how you met, to what you ate for breakfast, to who does the laundry. Officers are sometimes friendly, sometimes terse, and occasionally adversarial. They are looking for any sign that the marriage is fraudulent, meaning entered into for an immigration benefit rather than a genuine commitment. How do you prepare? First, both spouses should review the application and supporting documents thoroughly. Know what you submitted. Know the story of your relationship, not as a rehearsed script, but as a genuine narrative you can speak to naturally. Second, bring original versions of every document you submitted. Third, be honest. Immigration officers are experienced at detecting inconsistencies, and a small contradiction on something minor looks worse than a straightforward answer about something complicated. Some officers will interview spouses together. Some will interview them separately. If you are separated, both spouses must be able to answer questions about your shared life without comparing notes. Common mistakes that delay or derail cases. Let me name the mistakes I see most often. Filing without adequate joint evidence is the most common issue. People submit the petition, but their shared life documentation is thin. Start building this file from the day you get married, not the day you file. Missing this financial sponsorship threshold is another frequent problem. The sponsor must show income above a certain level relative to household size. If you do not meet that threshold, don't worry, you can use assets or find a joint sponsor, but you must proactively address it, not hope no one notices. Failing to disclose prior immigration history is serious. If your spouse overstayed a visa, was previously in removal proceedings, had any prior immigration court history, that information needs to be disclosed and addressed up front. Discovering it at the interview stage is far more damaging than raising it proactively in the application. Delays from requests for additional evidence are often avoidable with a complete initial filing. Read every instruction carefully, include everything asked for, and respond to any RFE within the deadline. Timeline expectations. For a U.S. citizen petitioning a spouse who is in the United States adjusting status, the realistic total timeline is roughly 1 to 2 years from filing the green card to approval, depending on the USCIS Service Center and current processing times. For consular processing, add the National Visa Center processing times and the embassy scheduling backlog at the relevant post. Some embassies have very long interview queues, others move quickly. For lawful permanent residents petitioning for a spouse, add the wait for a visa number to become available, which can push the total timeline to 2 to 4 years or longer, depending on the country of birth. What Elena and Marcus are experiencing, the waiting, the document request, the anticipation ahead of their interview, is completely normal. It's slow, it's bureaucratic, and it feels endless when you are living it. But it is a process with an endpoint, and preparation makes every step go more smoothly. The goal is to file a complete, well-documented case the first time. The more thorough your initial submission, the less likely you are to face delays. And the more you understand the process, the less the waiting feels like chaos. If you are facing marriage green card scrutiny under the current administration, I have a full video on exactly what USCIS is looking for right now and how to prepare. It's linked right here. I'm Kate Lincoln-Goldfinch. At Lincoln-Goldfinch Law, we guide families through this process every day. If you are petitioning for your spouse, please talk to an immigration attorney. Subscribe for more.